I guess all it took was a couple of years and a new president to change some minds on the Supreme Court about how to use race when drawing congressional district maps. The conservative supermajority seems now open to limiting how race can be used, which in turn could impact the power of your vote and who will represent you. And this ruling will ultimately have major implications for all future elections. So today, the justices heard oral arguments for about 2.5 hours in a case out of Louisiana. So this whole case centers around the state's congressional district map. And as we talk about all the time on my channel, the founding fathers believed that those district maps should be drawn fairly based on population and should be proportional. Well, in 2022, a federal judge ruled the way Louisiana lawmakers drew their congressional map violated Section 2 of the landmark 1965 Voting Rights Act because those lawmakers racially gerrymandered the map to eliminate a black voting district. Instead of two, they drew a new map with just one district, which then diluted the power of the black voters who actually lived in that part of Louisiana. Now, because of that judge's decision, Louisiana lawmakers had to go back to the drawing board and redraw that congressional map. And so they added that second black district back. But then another group calling themselves non-African American voters sued, saying that new map with those two black districts now violates the 14th Amendment's Equal Protection Clause. The state of Louisiana and the Trump administration agreed, and they joined the case. Well, in court today, the state of Louisiana and the Trump administration argued to the justices that race played way too big of a role in that decision to add back that second black district. The state of Louisiana argued that Louisiana has changed over the years, and the need to protect minorities and their voting power through Section 2 of the Voting Rights Act isn't necessary like it was in the 1960s or 80s or even in the early 2000s. The Trump administration argued that, well, states should be allowed to factor race into their redistricting decisions, but only if race-neutral factors are considered first. So what's a race-neutral factor? I'm not kidding. The Trump administration said, gerrymandering a map just to protect an incumbent lawmaker is an example of a race-neutral factor that should be considered before the actual race of the people who live in that area. The lawyer defending Louisiana's black voters said, all of that is nonsense. She said Louisiana may have changed a little bit over the years, but not enough to strip out Section 2 protections of the Voting Rights Act. She argued the state is actively engaging in a practice called packing and cracking, which in this case means packing all of Louisiana's black voters into just one district so they would, in theory, only be able to elect one representative instead of the number that would be proportional to their population size in the state. And cracking the black voters in this context means drawing weird congressional map lines in an effort to spread those black voters out into several districts in an effort to dilute their voting power.
6 appellate judges affirmed findings that Louisiana, in the face of extreme racially polarized voting, packed and cracked black voters, and it rejected 7 non-dilutive maps in favor of one that would give its 58% declining white electorate entrenched control over 83% of the congressional districts.
Now, here's where things get interesting. Before I tell you about how the justices reacted to all of these arguments today, I want to remind you of an almost identical case this very same Supreme Court ruled on in 2023, just like 2 years ago. In Allen v. Milligan, the justices ruled 5-4 that lawmakers in Alabama drew a gerrymandered district map that absolutely diluted the black vote by eliminating one of their districts. And the justices found that Alabama definitely violated Section 2 of the Voting Rights Act. The 3 liberal justices signed on to that majority ruling, along with conservative Justice Brett Kavanaugh and Chief Justice John Roberts, who actually wrote the majority opinion. But today, both Roberts and Kavanaugh seem to have a change of heart and mind about allowing race as a factor when considering drawing district maps. Kavanaugh seemed to sympathize with the state of Louisiana and suggested that it may be time for race factors to just go away.
This court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint.
Now, if the justices rule that race-based factors should be limited when drawing district maps, you can expect that state lawmakers across the country will absolutely gerrymander the crap out of their maps to protect or enhance their majorities or their incumbents.